If there is a risk to your water bills, if there is the potential that they might be challenged, I think it's much more likely it would occur as a result of NAFTA or one of the other FTAs that included the investment chapter that we discussed earlier this morning. In fact, the two most significant NAFTA cases have both were concerned with regulation of groundwater. These two cases, one is called Methanex and one is called Metalclad. The trade tribunals that were convened to hear these NAFTA cases reached somewhat different conclusions, and the reasons they came to different conclusions are relevant to this debate. In Metalclad, a U.S. company called Metalclad challenged the right of a Mexican municipality to prevent them from opening a hazardous waste facility that happened to the plan for which was to be built essentially atop the town's aquifer. And the issue with Metalclad was that the federal government of Mexico had told Metalclad, had made specific assurances to Metalclad that they could open and operate this facility. Yes, they had to get a municipal permit, but the federal officials said, we'll take care of that. In other words, we won't let this municipality stand in your way. Well, the municipality, which is called San Luis Potosi, did in fact refuse to issue the Metalclad company a permit. Metalclad took the case to the NAFTA Chapter 11 Investment Tribunal, seeking $14 million in damages. It pointed to the fact that it had an assurance that it would be able to open this facility. And the tribunal in the Metalclad case agreed with the U.S. company Metalclad and ordered the Mexican federal government to pay $14 million in damages. The reason that the Mexican federal government was on the hook for these damages is because it is the federal government of Mexico and our federal government that is the actual signatory to NAFTA, even if the case concerned the actions of a subnational government, either a state or a municipality. The second case is the Methanex case. In that case, the state of California banned the use in the state of the gasoline additive MTBE. The Methanex Corporation of Canada sued using the NAFTA Chapter 11, said there were other ways to regulate MTBE, that the problem was not the additive it was making, it was the problem that California had leaking underground storage tanks for petroleum and gasoline. So Methanex said if you wanted to fix this problem and not impose a burden on commerce and not damage international trade, then California just simply dig up every single one of its underground storage tanks and fix it. California said, forget it, we're banning it. And they did. Methanex sued for $960 million based on the loss of access to the California market and based on the loss of the expectation of future profits. Fast forward for 5 years, and the decision of the NAFTA tribunal in that case was that Methanex did not have a right. California was within its police powers to ban MTBE, citing the environmental provisions. So what was different about these two cases? Well, one is the Metalclad case came earlier in time, and it is possible that the tribunals were sensitive to the political ramifications of finding against California in the Methanex case. But one of the key differences in the fact patterns is that it appeared that Metalclad had been singled out in a way that the Methanex Corporation was not. The other problem with these NAFTA cases is they're not formally precedential, that each fact pattern is considered anew, And while trade tribunal members, that is the international lawyers who sit on these trade tribunals, will on occasion refer to other cases, they're not obligated to do so the way that U.S. judges are supposed to look at legal precedent. So they can essentially create new law or new approaches based on what they're finding. There's one last case called the Glamis case, which I won't go into, but it also involves the question of extraction. In this case, it's mineral extraction, and again, California, what's being challenged is the California law. The United States has never lost a case, which is great for the United States, but not so great for the credibility of the system. Canadians have lost a case, Mexicans have lost a case, and if you look at the number of cases that were filed around water in South America, particularly in Bolivia and Argentina, those tribunals have been very friendly to investors and have consistently decided against the Bolivians and the Argentines. Argentina, by the way, is on the hook, is facing $20 billion in total claims using the international investment agreement system, which would be essentially enough to bankrupt that country because of these international investor agreements, if they were to lose them all. And they've already lost some, and they're appealing them, and they're trying to find ways not to have to pay these cash damages to the corporations who brought them into court. I haven't had a chance to review all the bills. Again, some of them are still in the revisor's office. It seems that there's a range of possible proposals going forward, and it would appear that the opportunity to review the legal options is quite important. As someone who's worked in this area, I would note that thus far these disputes at the municipal level have led to sort of hand-to-hand combat, that there isn't an overarching framework for looking at this. That may be advantageous in communities that are well organized, but it still raises the question of, as in the Metalclad case, if there's the feeling that a particular investor is being singled out and targeted, that may be reason enough for them to want to bring a claim. Now, we know that in some cases, the companies that are asking for permission to withdraw groundwater in Maine have said that they don't see how the international trade rules apply. They cite an opinion that is now, I believe, 6 years old from the New Hampshire Attorney General's office that said, well, we don't exactly see how they apply. But that particular opinion basically looked at the trade rules and not the investment rules. It is simply incorrect to say that the international trade agreements can't apply in any of these cases. What matters is the identity and nationality of the investors. The standard that's used in NAFTA and other free trade agreements is that an investor has to establish that it is domiciled or has a substantial business presence in another country, a country with which the United States has a free trade agreement. So that list would include Canada, Mexico, Singapore, Morocco, Australia, et cetera, et cetera. Not the European Union, and then not the European countries. But what matters, again, is how that investment is organized. It is also possible for a U.S. corporation to set up a subsidiary in a third country, make the investment back into the United States through that shell company, and use the privileges under the international investment agreements to bring a claim. So until we know more about the corporate structures of those who are seeking these withdrawal permits, before we know the identity of those investors and the capital structure of those investments, it is premature for anybody to say the trade rules don't apply. As far as we know, no state has of yet tested the jurisdictional questions by writing into statute, well, the NAFTA rules don't apply. If you were to do that, you can almost assure yourself that there would be a constitutional challenge of one kind or another. I personally don't know of a precedent whereby a state has required the disclosure of investments, and this is not something that I could advise on. I talked to my colleagues about it last night, and they said, you know, traditionally these are things that are regulated at the federal level by the Security Exchange Commission, and you would probably want to get a securities lawyer to look at this question. Maybe Linda has some thoughts on this. But the point of the story is, both in terms of the international investment rules and in terms of the regulation of groundwater and the interaction between them, we're in new territory.